Hello, good evening everyone. Welcome. My name is Olivera Simic and I'm an academic with the Griffith Law School. Before we start with the formal proceedings, I would like to acknowledge the traditional owners on the land, the Drumbl and Jagera people of which we gather, and elders past, present and emerging. Tonight I have a great pleasure to introduce Professor Mark Drumbl, my colleague and friend who came from Washington Lee University, to talk to us today about the war crime of attacking cultural property. Mark Drumbl is the class of 1975 alumni professor at Washington Lee University School of Law, where he also serves as the director of the Transitional Law Institute. He lectures, practices, and publishes widely in the area of international criminal law, post-conflict justice, and public international law. His book, Atrocity, Punishment, and International Law, has won commendations from the International Association of Criminal Law and the American Society of International Law. In 2012, he published Reimagining Child Soldiers in International Law and Policy, which has been effusively reviewed and critically acclaimed. He is co-editing the Research Handbook on Child Soldiers at the moment, right, Mark? That's happening right now. And he has additionally taught a number of law faculties, including Oxford, Paris, Melbourne, Monash, Ottawa, and the Free University of Amsterdam. He's just here in Australia to teach at the Monash University intensive course in international criminal law, and we are very delighted that he had a time to come and talk to us about the war crime on cultural property. Please join me in welcoming Professor Mark Drumbl.
Thanks. So it's really quite a great pleasure to be here and to spend a bit of time in Brisbane. It's much warmer and sunnier here than in Melbourne, so that's one positive step, and it's been a lot of fun. And last night it was really great to share in with Ollie's book at her book launch, and that was a tremendous amount of fun, and it's great to see Sharon again. So, all right, so let's move away from openings and introductions and politesses to some more tough questions. Let's start off here. Okay, that's not a good way to start. That's a good way to start. That is Timbuktu. What is Timbuktu? Timbuktu is an iconic, emblematic city in northern Mali. In the 15th and 16th century, it was an intellectual center, a trading hub, a focal point for the spread of Islam in the region, a place redolent of and with libraries, learning, thinking, creativity, shrines, mausoleums. It's mystical, evocative, full of art, full of Sufism. And through time, the evocative nature of Timbuktu continues, and in the modern era, UNESCO designates Timbuktu on the World Heritage List. The buildings are spectacular, they're aesthetically appealing, they're gentle, they're undulating, and there's a magnificence to them. So let me take you from this building to this building. What's that? It's the International Criminal Court in The Hague. International Criminal Court, as you know, came into force in 2002. It was created by an instrument called the Rome Statute of the International Criminal Court, which was adopted in 1998. Currently, there's 123 states parties, and what does the International Criminal Court do? It prosecutes individuals accused of the most serious of crimes against the world community, war crimes, genocide, crimes against humanity, and inchoately, possibly the crime of aggression. The ambitions of the ICC are lofty and altitudinous, but its gait is shuffling and its shoulders are sloped, and to date, since 2002, the track record of judicial accomplishment is infinitesimally small. 4 cases have gone fully to trial, 3 convicts, 1 convict acquitted on appeal this particular year. So how does Timbuktu get to The Hague? It's this man, Ahmad al-Mahdi. Al-Mahdi is a Quranic teacher and scholar in Timbuktu. He's a member of a group called Ansar Dine, which is a group affiliated with Al-Qaeda in the Maghreb. And in January of 2012, fighting escalates in northern Mali between Al-Qaeda in the Maghreb and the government of Mali. An internal armed conflict ensues. And Ansar-Dine and Al-Qaeda in the Maghreb, an extremist Salafist force, take over the region, and they take over Timbuktu. And they retain control of Timbuktu for a couple of years. As rebels taking control of the city, they seek the formation of an independent state, which is called Azawad. They create Islamic courts, local government, tribunals. They create police force and a morality brigade. And the morality brigade is called the Hezbollah. And al-Mahdi is the leader of the Hezbollah. Al-Mahdi is neither superior nor subordinate. What do I mean? He's in the middle. He has superiors, and he has enough situational authority himself to claim control over subordinates. So what happens when Al-Qaeda in the Maghreb, Ansar-Dine, is running and controlling Timbuktu? I can show you in pictures, and I can show you in video. And let's see if this works. This is the opening of a very powerful film made in 2014 called Timbuktu. It's a Franco-Mauritanian production, and it's supposed to be silent, but just listen. That's what happens. The property of a cultural nature and value in Timbuktu ends up becoming systematically damaged and destroyed. And al-Mahdi is charged at the International Criminal Court on the charge of the war crime of intentional attacks on cultural property. The government of Mali refers the case of violence by this rebel group to the International Criminal Court, which forms part of a broader pattern of what are called self-referrals, where governments have referred the violence committed by rebel groups to the International Criminal Court, and the al-Mahdi case goes forward. He is charged with the war crime under Article 82E4 of the Rome Statute. It's a law talk. I got to put in some clauses and numbers, right? So, which prohibits, as a war crime, intentionally directing attacks against buildings dedicated to religion, education, art, science, or charitable purposes, historic monuments, hospitals, or places where the sick and wounded are collected, which are not military objectives. If you note textually in the language, culture never appears, even though the entire subjacent aspect of the conversation is the destruction and attacks on cultural property. And fundamentally, this case is all about cultural property, its destruction, its protection. In fact, Chief Prosecutor Fatou Bensouda of the International Criminal Court Office of the Prosecution, in her opening statement, opened with quite a bit of a banality, but it shows what the argument is about, namely, quote, culture is who we are, and that is the justification for proceeding with this particular charge against al-Mahdi. So how does the law come down? The law comes down very quickly in this case, and it comes down quickly because al-Mahdi pleads guilty. In September of 2016, he receives a 9-year sentence. A 3-judge panel in a trial chamber of the International Criminal Court unanimously finds him guilty of the crime under H2E4 that I just read out to you, and his guilty plea is accepted, and he gets a 9-year sentence. In specific detail, he committed 9 acts of destruction on 9 historic Sufi shrines. These were built out of mud and brick over the graves of Sufi saints, and also destroyed part of, including also the door of a renowned mosque. The door of the mosque was said to lead to the Last Judgment if it ever were opened. It had remained closed for 500 years. Al-Mahdi and his subordinates pickaxe it open. Al-Mahdi case is a first in 3 areas. The first guilty plea at the International Criminal Court, the first cultural property case leading to a conviction at the International Criminal Court, and it's the first among the least because al-Mahdi has received the least long sentence of anyone at the International Criminal Court, this being 9 years. Now, it's not that much less than other individuals who've received sentences of 12 and 14 years, but 9 is still less than those. There was one sentence in the Bemba case of 18 years, but Bemba was acquitted on appeal. This is not the first time an international penal institution has convicted for crimes against cultural property. The International Criminal Tribunal for the former Yugoslavia convicted on cultural property destruction for the shelling of Dubrovnik. And there was another case that was brought regarding the old bridge in Mostar in the former Yugoslavia, but ultimately on appeal in 2017, a conviction that had been entered for cultural property destruction in that case was overturned on appeal on the basis of military necessity. There's also a handful of cultural property destruction cases from World War II. A French tribunal convicted someone for destroying a statue of Jeanne d'Arc, and there were 1 or 2 others that involved destruction of Jewish cultural property. So what I want to do here, I want to do 2 things. First, I want to tell you the story of the case in greater detail from a doctrinal perspective. And then what I want to do is elevate the conversation into more of a theoretical frame. And what I'd like to do is to chide the case. Why? Because it actually tells us very little about how, why, and what cultural property is, and it tells us even less about why cultural property ought to be protected. And I fear that a politically convenient case of a guilty plea from a politically unpopular Islamist can in turn lead from an easy conviction to a form of precedent that can be slightly risky, a little combustible, and potentially volatile when applied into a variety of other contexts. And that's what I would like to be the note on which I end. Okay, so let's talk through a little bit of the law. Now, al-Mahdi was charged as a co-perpetrator. There's actually another case that is currently moving forward at the International Criminal Court involving another member affiliated with al-Mahdi on different charges. Note that this case only involves the charge of cultural property attacks. There was plenty of violence in northern Mali: rape, sexual assault, murder, massacre, destruction of many things, not only cultural property. But this is the one case that went forward on this one particular aspect. He pled guilty, but the ICC as a court has to assure itself that the guilty plea is legitimate, plausible, based on evidence. So the first thing the judges do in the judgment is satisfy themselves of that. And for 5 reasons, they accept the guilty plea. First, they find that on the evidence it is demonstrated that al-Mahdi supervised the execution of operations. Secondly, he collected, bought, and distributed the necessary tools and materials, gave Hezbollah the money, and Hezbollah, remember the morality brigade, moved forward. Pickaxes, shovels, and bulldozers. And here you can see some of the acts of destruction on one of the shrines. Thirdly, al-Mahdi was present at all of the attack sites, and he gave instructions and moral support to the individuals doing the destruction. Fourthly, and I think most importantly, he went public. He vigorously and rigorously defended the attacks on cultural property and the particular sites to journalists, couching it within the language of the sites, the Sufi sites, as being laced with hereticism, being places of the infidel, and as violating the fundamental tenets of Salafism. And finally, he personally participated in the destruction of 5 of the sites, roughly half of the sites, and taken together those 5 pieces of evidence justified his own guilty plea. So the bulk of the judgment from September 2016 involves the question of sentencing. And if the International Criminal Court, as Sharam well knows, as an expert on sentencing, there's 2 stages of analysis. The first is the judges have to determine the gravity of the offense, and then secondly, the judges have to consider what are called individual circumstances, namely aggravating and mitigating factors that relate to the actual accused. So the first step is, what did he or she do? And the second are factors that relate to the person, him or herself. Now, when it comes to the gravity of the offense, the judges identified 4 particularly important factors. The judges recognized that the violence in question did not involve people. It involved things. It involved property. And from a retributive perspective, violence against an inanimate object is going to be seen as different than violence against an animate object. What the court does is it underscores the salience, relevance, meaning of the physical cultural property to human beings. And it links the destruction of the thing to the destruction of the person. And in this regard, it underscores how people in the area actively use these shrines for religious purposes. They formed cornerstones, touchstones, and keystones of the community. They were routinely and frequently availed by individuals, and therefore their destruction led to human suffering. I'm going to put an asterisk here. I'm going to come back to this later on, because it's also a slightly problematic point. Second major factor of the gravity, UNESCO protected these places, and therefore attacks on these places were attacks on UNESCO, were attacks on the international community. And here al-Mahdi did himself no favors by routinely calling UNESCO a bunch of jackasses and saying that destroying these properties ended up destroying jackasses who ended up worshiping cows and individuals and ideas as opposed to necessarily Quran as the Quran ought to have been interpreted. Thirdly, the court underscored when it came to gravity that al-Mahdi's attacks were carefully planned. They were actually quite surgical. He only destroyed the specific physical plant that did not accord with publicly circulated understandings of Islam that the Hezbollah circulated publicly. This wasn't indiscriminate random violence. This was surgery. It was thoughtful. The court finds, however, that because of the mens rea and mental element, all of the deliberation and planning that goes into thoughtful surgery as opposed to indiscriminate destruction, that actually indicates much more of the gravity of the offense and a culpable mind. And fourthly, of course, the court is concerned with the gravity relating to al-Mahdi's adumbration of a discriminatory religious motive. Once again, rooting in the intentionality. Those are the 4 factors of gravity. Individualization. The court finds no aggravating factors. It finds 5 mitigating factors. First, foremost, his guilty plea. A huge discount is given to that. Secondly, he not only pled guilty begrudgingly, he cooperated very actively with the prosecutors. Thirdly, he expressed remorse and empathy, did so quite openly and publicly, speaking directly to the people of Timbuktu. Fourth, Al-Mahdi initially was reluctant to damage and destroy the cultural property. He didn't want to at first. His superiors cajoled him into doing it. Then he came to see the light, or the dark, so to speak, and did it, and publicly justified it with great vim and vigor. But the court found as a mitigating factor his initial reluctance, and also how he surgically limited the damage only to that which was absolutely required by the tenets of Islam that he understood them to be. And here we have this strange paradox. The surgical nature of the destruction is a gravity factor, and it's also a mitigating factor, because in the end of the day, he did less damage and avoided wanton harm. There's a paradox there. And finally, he engaged in good behavior in detention. He was polite and at all times was cooperative. All this together leads to a 9-year sentence. One last bit of legal doctrine. In addition to being able to criminally sentence people, the framework of the Rome Statute of the International Criminal Court also permits reparations and orders for reparative justice. This can be made against the accused, but all the accused are impecunious anyway, so by and large, the funds that satisfy the reparative orders come from an entity called the Victims' Trust Fund, which is largely capitalized by donations from states that want to give money to it. The ICC's fervent hope is that Bill and Melinda Gates and private philanthropists will actually fund. That has not yet happened, so it's still from states. On August 17th, 2017, a reparative order is issued in the Al-Mahdi case. 2.7 million euros in damages are awarded for the harms committed by Al-Mahdi. The 2.7 million are assessed by a financial calculation of the damages directly related to the attack. The economic loss is a second element, mostly tourism. And thirdly, the moral harm. And who gets the money? Who are the victims? The International Criminal Court, in its reparative judgment, identified 3 sets of victims entitled to reparative claims and finances. First, the inhabitants of Timbuktu. Secondly, the population of Mali. And thirdly, the international community, which received €1 in symbolic compensation. So that's the law. Now, I have 6 or 7 points that I'd like to make that riff off of this case as precedent, this case as slightly hollow and underthought, and this case as also slightly worrisome. But before I get to it, good news. All the damaged stuff has been rebuilt and reconstructed through private funds, which is interesting for me because part of the reparative order coming out of the Victims' Trust Fund is for reconstruction. But a lot of the things have already been reconstructed. It's a good thing. Example up there. All right, so let me roll through these and then we're going to have some time for conversation. First, what's the theoretical justification for protecting cultural property? There's 2 major schools of thought. One is what one would loosely call the cosmopolitan and international justification, and the second is what one would call the nationalist or localist justification. The cosmopolitan vision suggests that we protect cultural property because it is part of the biodiversity of the human species. We all have an interest in the diversity of culture, diverse strands of culture that manifest themselves elegantly and beautifully through language, literature, art, architecture. You get the picture. The second justification is nationalist or localist. This ought to be protected and its destruction ought to be criminalized because people living in the region where the culture is, who identify with that particular culture, derive pride, meaning, solidarity, camaraderie, identity from that particular cultural product and property. Now, neither the reparative judgment nor the penal judgment actually engage with cultural property theory. The penal judgment gives a nod to the internationalist cosmopolitan justification for protecting it, in particular through its invocation of UNESCO and UNESCO's designation of this cultural property as being on the World Heritage List, and seeing that as both a factor in gravity and also a factor in accepting the guilty plea. But the reparative judgment focuses much more on the local value to people in Timbuktu of the cultural property. And in a very interesting move, the reparative judgment actually includes in reparations the economic harm and the economic loss occasioned by the destruction of these religious sites, which in many ways moves the reparative judgment outside entirely of the language of cultural property and much more into the language of pillage or destruction of private property, compensation for destruction of civilian property. It's much more the nationalist, localist view. At the end of the day, primarily the International Criminal Court is a penal institution, and hence these internationalist cosmopolitan strains and strands that come out of the majority judgments indicate more where the mindset and headspace of the court is. And of course, everyone in international law loves cosmopolitanism. We're a happy global community, and when someone is hurt in a distant corner, we also are hurt, and international institutions will come to the rescue. So this sits very comfortably, not queasily, but comfortably with international lawyers. But there's a shadow side to all this, and I make the argument in the paper that the internationalist justification for protecting cultural property can be very problematic. Work with me through this syllogism. If it's a crime to destroy these shrines, that means necessarily that individuals have a right to enjoy those particular shrines. And if individuals have a right to enjoy the shrines, and if it's a crime to destroy them, does that not mean that the state in question, that has jurisdiction over the particular cultural property, has a duty to protect that particular property? Well, what happens if the state can't protect the particular property that it has a duty to protect, that its citizens, or citizens everywhere in the world, because we're all cosmopolitans, that citizens everywhere in the world have a right to enjoy, and that a citizen anywhere in the world who destroys it is a criminal? What happens if the state can't protect it? I would make the argument that leads to a protect or expatriate scenario. Just like a duty to prosecute human rights abuses, if the state can't do it, the state's under a duty to prosecute or to extradite. Well, if cultural property requires protection and the state can't do it, then the state is under a duty to protect. If it can't, it's under an obligation to expatriate the cultural property. Well, this is music to the ears of the British Museum, the Louvre, the Met, the African Museum in Brussels. This is music to the ears of the temples of theft that are full of stolen property, but are beautifully maintained to the highest level of scientific and aesthetic quality, that are accessible to all in places that are easy to visit, that are conserved with absolute professionalism. So in many ways, the Al-Mahdi case is a first step through a syllogistic analysis of a justification for the Elgin marbles remaining where they are. And the wealth of Egyptian patrimony being scattered over the metropoles of the world, because after all, the one King Tut mask that was in Cairo, the beard broke off, and what happens when the beard broke off? The museum curator crazy glued it back on, causing almost irreparable damage until, of course, the Met could save the day and somehow fix the very messy repair job that was done in Cairo. So that's one important aspect for me. Something that seems so self-evident can actually turn into a justification for something that's far less self-evident. The second point that I want to talk about, I flagged it for you earlier. It's this idea that this is particularly bad because devotionally people loved this and used it a lot. And the arguments in which I opened, and the court also opened, these ideas of Timbuktu as emblematic, iconic, mystical. I mean, this stuff is beautiful. It's beautiful. It's just beautiful. It's easy to love this. So if it's easy to love it, if it's frequently used, if it's popular, if it's sort of, top of the charts, if that makes its destruction worse because of its popularity, where does that leave ugly, dusty, dismal, forlorn, ignored, gross cultural stuff? What happens to that stuff? What happens to the stuff that's never used? Do you remember I think it was in 2000, the Taliban detonated the Bamiyan Buddhas. The Bamiyan Buddhas are these two enormous statues at the base of a valley that used to guard Buddhist communities that were in the valley. The last records of Buddhism in Afghanistan trace back to 1336. The Bamiyan Buddhas guard something that no one has used for 700 years, roughly. So does that mean that their destruction is somehow less serious, less grave, because the stuff is never used? What about Palmyra in Syria, that ISIS destroyed in part? That's part of a culture that isn't even in any way, shape, or form identifiable with the modern Syrian nation state or the modern Iraq nation state. There's other acts of cultural property destruction that ISIS has undertaken. What about cultural property that's not made by people? What about natural, parts of the natural topography? Hills, valleys. Many indigenous cultures ascribe tremendous cultural salience to stuff that no human hand ever made. And in fact, no human hand even ought to touch it because of its sacred value. Where does that leave that stuff? So I think the anthropocentric nature of seeing the value in cultural property leaves the most forlorn, the most lost, in actually a fairly lonely place. So in the hype to show the value of this to people and say that that's why its destruction is particularly bad, we're once again favoring the beautiful and that which is always touched over untouchable cultural property, or just the ugly kitsch stuff that no one really likes, or the stuff that was never made by human hands. Thirdly, this UNESCO thing. So UNESCO, which is one of the larger international organizations in the United Nations framework, now becomes a legal expert. Because when UNESCO designates something now as cultural property, then all of a sudden its destruction is of stratospheric concern to the international community. Heavy reliance is placed on UNESCO. How much do we actually know about the UNESCO process by which cultural property is selected to be added to the World Heritage List? Very little. The process has been routinely criticized by art historians, curators, architects, as being notoriously political, deeply Eurocentric, and often resulting from bargaining chips by certain states being able to list more of their stuff than other states. So I think one thing we need to be very careful of is an organization whose decisions are made in a certain way suddenly become deeply probative in a juridical context. Does that not mean that we ought to have greater transparency in terms of how that organization comes to make the decisions that it does? I believe we should. Ironic to me is now UNESCO is having a deep love affair with the International Criminal Court. The International Criminal Court Office of the Prosecutor and UNESCO have signed, to great florid nature, cooperation agreements, ententes, and so forth. It's sort of a mutual revitalization of two somewhat moribund international institutions. But that belies the deeper question about when we rely on external evidence of something's value in a legal context, should the decision by the external actor as to someone or something's validity not also be subject to a level of scrutiny? Fourth, and this is inevitable in a plea bargain, a whole bunch of jurisprudential stuff was not addressed in this case at all. Notably, the military objective exception to the destruction of cultural property. Because you can destroy all the stuff in the Rome Statute provision if it satisfies the military objective. Here there was none. And in fact, one of the major critiques of the Al-Mahdi case is that there wasn't even really an armed conflict going on in Timbuktu at the time when that property was destroyed. It was under occupation. And if you watch the film, well, the film is, I showed you the intro, the Timbuktu film. It's so sadly beautiful. It tells the story of this cattle herder, Kizane, and one of his cows destroys the fishing nets of a fisherman, and then they get in a fight together, and he kills the fisherman. And the fisherman's family will not forgive him for the murder, so Kizane gets sentenced to death by the Islamic tribunal set up by the Hezbollah. And throughout this entire film, you can really see the effects of the Hezbollah in Timbuktu, public floggings, terrible gender-based discrimination, the opening of the film, the destruction of all these statues, and so forth. But that's different than an armed conflict. But still, in this particular case, inevitably related to the plea bargain, a whole bunch of stuff doesn't get adjudicated. Fifth, in all the excitement of prosecuting this new crime of cultural property destruction, many, many other crimes were left off the table. Fortunately, a second case is coming up, and that second case, I hope, in terms of expressive value, will be able to have a broader conversation of a deep level of the violence that existed in Mali at the time. And the sixth point for me is the most important one, and the most poorly thought, and the most problematic. And that is the interface between the protection of cultural property and the criminalization of its destruction, the interface between that, on the one hand, and transitional justice on the other hand. So, if it is a crime to destroy cultural property, what does that mean for societies that seek to overcome cultural hegemony or cultural oppression, or seek to move themselves away from periods of systematic human rights abuses? Let's start off with this. The major move that has been made in international human rights law over the past 50 years is the move that says that every individual, no matter how ugly, misanthropic, creepy, beautiful, elegant, smart, ignorant, or crude, every human being is entitled to a core level of universal human rights. No individual can be destroyed or demolished. Restraints may be put on people's liberty, but they have to be shown, for example, through a criminal process. So, life used to be that certain people got more rights juridically because they were better or in certain categories, and the major move we have made in international human rights law is to move away from that. If you're born, you're a person, you have a certain base level of human rights. Okay. So, if it is now a crime to destroy cultural property, that therefore means that anything that counts as a culture is entitled to protection. And its accoutrements, its artifacts, its architecture, its monuments, its books can't be destroyed. So therefore, how do we determine what culture is? I will tell you one group that is extremely interested in the Almaty case. And it's groups in the United States, like the Daughters of the Confederacy and the Veterans of the Confederacy, that make an argument if shrines can't be destroyed, and if it's a crime to destroy the shrines, then surely it also ought to be a crime to destroy monuments set up to honor the war dead of the Confederacy. And it's hard to refute that argument. And we can go from there in a whole variety of other places. Is it a crime when the Czechs and the Poles tore down statues of Stalin, Marx, and Lenin? Is it a war crime when the Americans toppled the statue of Saddam Hussein in Baghdad? Is it a war crime or a crime against humanity, or even just a crime to destroy monuments set up through settler colonialism? What do we do with those sorts of monuments? This beautiful culture, if something is a culture, then it would be entitled universally to the same protection. Just like beautiful people get the same protection as ugly people. Now, in practice, beautiful people always do better, but that's different than what is the judicial rights entitlement. It's a separate question. Let's move into transitional justice again. In times of cultural change, does that mean that cultural monuments can never be changed through destruction? Does every aspect of appropriate cultural change have to be through bricolage? Does the Hagia Sophia in Istanbul stand as the only way in which to advance, change, modify civilization by bricolage, by adding things here or there, such that what is the culture of the Hagia Sophia? I don't know. Revolution and liberation has always interfaced with toppling the accoutrements of the past that often become vilified and putting new ones in place. But maybe you can't do that anymore. The heart of cultural property protection emerges from the 1954 Hague Convention on Cultural Property. That was set up after World War II, and it relates to this specific notion that State A should be barred from invading State B and burning down all the books in State B that relate to the poetry, language, literature, destroying all the paintings, shattering all the museums. But this is a different form of cultural property change. It's change within a particular group, within a particular faith community, of seeing things to be done differently than they were in the past, and surgically destroying that within the past that is seen as heretical. What is the interface between progress, liberation, change, when the cultural property of the past remains frozen because its destruction might be a crime? I think it's a very difficult question. But this case certainly stands for the protection of the past over the hands of change. And on this, I'll conclude. This very simple case opens up much more than it actually covers. And perhaps we can't expect more from the International Criminal Court. It's barely doing anything, and now we criticize it for not being sufficiently attuned to sophisticated theoretical insight and anticipating where its precedent may go. But I think we should do better, and we should expect more. And why is that? That's because one fact is of great salience. Almost every eliminationist, genocidal, persecutory, and discriminatory movement begins with targeting arts, language, literature, the cultural property of the group set for extirpation and persecution. In 1933, well before, 11 years before he coined the term genocide, Raphael Lemkin coined a different term called vandalism. And he felt that vandalism was one of the most egregious international crimes. Vandalism, in a nutshell, is cultural property destruction. Initially, Lemkin pushed very hard for cultural genocide and destruction of culture to form part of the Genocide Convention. He gave up on it. He also gave up on political groups being subject to genocide. But he gave up on cultural. Why? Because it wasn't going to fit politically within the negotiation of the 1948 Genocide Convention. The Soviets opposed political genocide. Canada and the UK and South Africa opposed cultural genocide. Why? Fearing that it would lead to the criminalization of colonialism. And I think it's important for this case to get it right, because culture is contested, and the destruction of culture is the first step in what metastasizes into full-scale massacre. I think it deserves more rigor in terms of analysis, because without that rigor, we won't have any vigor in the law when it actually becomes applied. So I think the story of this little case, an incomplete story, is one that deserves a second look. Thanks.